In the last few decades, one of the major shifts in business is that the assets of companies have gone more and more away from brick and mortar and natural resources into various forms of intellectual property. One of the most important forms of intellectual property is patents. So I'm going to take a few minutes and talk about what everybody should know about patents. First of all, there are three different types of patents that have effect on things. First is a utility patent, which is what most people think of as patent. The second is a design patent. A design patent protects the aesthetic look of something. So a chair isn't patentable for its functional features, generally, unless there's something new and unique about a suspension system or something. But its design may be protectable and in fact very valuable. There's some companies that make billions of dollars selling unique furniture, and so they're able to protect those designs by design patents. Finally, the last type of patent is a plant patent. They're relatively rare outside the agricultural community, so I'm not going to spend much time on those. First thing with a patent is it's important to understand what the purpose is. A patent is not a grant from the government that lets you do something. It's actually a grant that lets you prevent others from doing it. So it is entirely possible to get a patent on something and not be able to practice the patent because what you're doing is illegal, but you can exclude other people from doing that. In fact, one of the best examples is items relating to gambling. Right? If you have a slot machine, that slot machine may be illegal in most states in the United States, but you can prevent other people from making it. So you're effectively getting a patent on the state of Nevada or a few other states that may allow slot machines in the gambling. So you are granted the right to exclude others from making, using, selling, offering to sell, or importing. And each of those is important because you can stop somebody from making it, but what happens if the person making it's making it overseas? Well, then you can use the importation clause. Or what happens if nobody actually is making it per se, but somebody's assembling the parts and using it? So you may be able to stop them by using it. Relatively recently, they amended the statute to provide also selling and offering to sell. So you don't have to wait until there's an actual instance of infringement or an actual sale to go through before you can sue somebody to stop them. That's particularly important if you have patents on very large things, like for example, if you had a patent on the design of a manufacturing plant. You don't want to wait until the people have already sold and built a $25 million plant before you exercise your patent rights. So under the revision that allowed for offering to sell, you can proceed with a lawsuit as soon as the offer to sell is made. As for the length of a patent, for a utility patent, it's 20 years from the date, the first effective filing date of the application for a non-provisional application. So for most patents, that means they'll last 20 years. Now, many patents will actually last longer than 20 years because if the Patent and Trademark Office is slow in responding and getting the patent issued, they will actually perform what's called a patent term adjustment, where they give you additional days on the back end. So if you ever look at a patent and you see the filing date is January 1st, 2012, right? Normally that patent is going to expire January 1st, 2032, but you need to look to make sure that there's no patent term adjustment that may take it out 6 months or a year. I've actually had a couple issues where there were 4 or 5 years of patent term adjustment because the patent office was so slow in getting the application through the process. For design patents, it's 14 years from the date of issuance, although that is set to change very shortly to add an additional year on. One important thing with patents is that a patent means it's different. It doesn't mean it's better. It just means it's different. A lot of companies will hype, so good it's patented. Well, that doesn't mean it's a good thing. For example, on the left-hand side, we've got something that's pretty smart. Most of us would agree smartphones, in this case, an iPhone, is a good invention, and that's smart. On the left, we have the whiskey cup on top of a rifle. Whether you're a gun advocate or not, I think we can all agree that that's generally a pretty bad idea. Drinking, having whiskey drinking contests while you're shooting is, in my book, falls in the not so smart category. So just because it's patented doesn't mean it's better, it just means it's different. And in different, the patent office looks at a couple of things. Number one, they look at, has it ever been done before? That's called novelty. And then the second test is obviousness. Okay, even if the exact thing hasn't been done before, is it just a minor variation? If you built a car and I built one that's red, and I say, yeah, but mine's different because his is blue and mine's red, they're going to say, it's obvious to change the color on something, unless it provides some functional improvement. So what can you patent? You can patent a process, a machine, an article of manufacture, or a composition of matter. This has actually been a very hot issue in patent law for the last 5 years. The traditional test for a lot of method patents was as long as you have it tied to a machine, you're okay. And so everyone said, all right, well, as long as I've got a method, I'm tying it to a computer, so a method of doing something with a computer, I'm okay. Well, last year the Supreme Court came out and said, no, that doesn't work. If it's a well-known, like a business process or something that you're simply applying through a computer, that is not patent eligible subject matter. It's a case called CLS versus, Bank versus Alice. And that has sent shockwaves through the patent community as patents have fallen left and right. There's been dozens and dozens of cases where courts have ruled patents to be invalid on motions to dismiss at the very front end of the case. So it's really revolutionized this analysis. And it's very important when you're trying to protect your intellectual property to have a very frank discussion with your patent attorney about, is this protectable? Or how do I protect it best in light of the recent changes in the case law? You can also do an improvement on any of those things. So if somebody has patented a mousetrap and you've invented a better way that that same mousetrap would work, you can obtain a patent. And sometimes those are actually the most valuable patents. If you can take something that was not commercially viable and with your addition make it commercially viable, the add-on patent, so to speak, can be worth far more than the underlying patent. And what often happens is the company that does the improvement ends up cross-licensing with the company that invented the item originally, because then they both have a marketable product. To be patentable, the invention must be useful, must have some utilitarian use. It doesn't have to have much, so if your patent is going down for lack of usefulness, you've got a problem, because you ought to be able to come up with some use for it. Secondly, it has to be novel, like we talked about, and then it has to be not obvious over the perimeter. Finally, some common pitfalls in patent law. Number one is documentation. Prior to 2013, documentation was very important from the point of view of when did the inventor create the invention, because patents were granted on whoever invented first. Now they're important, but the documentation is more important on what disclosures were made of the invention, because the disclosures can have a big impact under the new law on who gets priority, who has the first use, so to speak, that will ultimately be rewarded. Now, the new law, so the timing is once you offer something for sale or publicly disclose it, in the US you have a 1-year period in which to commercialize that product. Now, on March 16th of 2013, the law changed from the first to invent, which is why we wanted so much documentation about when you invented, to a first inventor to file. So in other words, who filed their patent application first is generally going to win, except if you had a product on the market before their filing date, that can actually be considered a filing, so to speak, that would prevent them from getting a patent. So that's a very nuanced area of law, and we should give a lot of consideration to. Finally, foreign patent protection. In most foreign countries, you have to have absolute novelty. It means no public disclosure. So if you want to protect your patent in other countries, it's very important to get that patent filed as quickly as possible. Otherwise, you may be losing your foreign rights. Thank you very much.